incredible work. Former Chief Justice Chase Rogers and I absolutely have been blown away by all of the work that you've done and by the time frame within which you've accomplished it. And we're sure that Chief Justice Robinson, who's joined us, will share in that enthusiasm. It's unbelievable that we are less than 1 year out from Steve Holmes, and that in only 5 months since our first meeting, that you've submitted for a vote your thoughtful proposals that can have an immediate and a significant impact on the fairness of our jury trials. With sincere thanks to Chief Justice Richard A. Robinson for creating this jury selection task force and for including all of us on it. We thank you all for giving so much of yourselves during such a trying year. My family, like many of yours, has been touched by this year's tragedies. Just today, we laid to rest my grandmother, Ruby Mae Dick Williams. But despite all of your personal and professional obstacles, you leaned on your expertise, on your work ethic, on your creativity, drive, and you've all come together and really have produced truly meaningful suggestions that will revamp our jury trial process and that will refocus our commitment to equal justice. So thank you for that. Lively and informed debate has shaped your proposals, just as it has helped to forge character-defining steps forward throughout our history. And the sometimes competing views within these final proposals speak to the strength and also the breadth of this comprehensive body of work that you've put forward. And they offer a wide array of possible ways to achieve the shared goals of this task force. So once again, thank you for staying true to your narrow charge and for adhering to a rather ambitious timeline while producing truly exceptional work. I also want to quickly offer special thanks to Melissa Farley, the Executive Director of External Affairs at Judicial, as she did some amazing work with your legislative proposals, making sure that they were submitted on time. And I also would like to offer great thanks to all of our court operations crew who worked so closely with all of you, and to all of our subcommittee chairs who did phenomenal work. Finally, a quick congratulations to Alex Gillette, who worked right up until the birth of her beautiful twin boys. And Chief Justice Rogers, is there anything I'm missing before we hear from each of the subcommittees?
No, I would just join in what you said. And the only personal comment I would have is in my prior life, I had the opportunity to review a lot of reports and a lot of work like this. And my view of what you all have done, this ranks right up at the top for two reasons. One, it's really meaty, it's comprehensive. There are some real changes here that are being recommended that can be done relatively easily, I think, if the Chief Justice agrees that they have merit. But more importantly, from a former Chief Justice perspective, they can be done, almost all of them, at little to no cost. So thank you, thank you, thank you. Again, just great work. We really do appreciate it.
So true. And we were just saying how it's, not only is the work so amazing and so creative and everything, but you also get to those points where you're saying, my gosh, we're not doing this already. It's just, you really came up with some phenomenal suggestions. So thank you, thank you, thank you. All right, and with that, we've had the opportunity to review all of your final proposals. So we're not asking the subcommittees to, sit here and read through them all. We've all had the chance to look through them. I would just ask for maybe a minute or two from the subcommittee chairs just to remind us what we're voting on. We'll hear from each subcommittee one at a time in allowing people to ask questions or provide any comments. Once we do all of that, we'll move toward a vote on the entire package of proposals that you've all put forward. So starting as we have, we'll start off with data statutes and rules with Dean Fisher and Attorney Howard. Is there anyone who would like to briefly summarize your proposal?
Thank you. Yeah, Tim Fisher here, reporting on behalf of both Claire and me and our subcommittee. So our recommendations, which you have, recommend that we establish a robust system of digital records of jury summoning and service from cradle to grave, from the first summons all the way through to who actually serves. The record keeping we propose will protect personally identifiable information, but yet on an anonymized basis will provide a very robust database for analyzing any element of disparate impact throughout the system. Our goal is to enable things to be achieved. One is to allow Batson challenges to be based on pattern and practice, which cannot be done now because it's basically anecdotal. Second is to give feedback to individual lawyers on any patterns in their own challenges. Third is to provide the judicial branch a very system of analyzing each stage of the jury selection process to identify bottlenecks where there is any disparate impact or unnecessary loss of potential candidates. And then finally, to enable other parties on the outside to do the kind of that would educate us, but also educate other states as to the successes of Connecticut's approach. So that's it. We earlier proposed a new subsection C to the statute 51-232 that would enable the judicial branch to do this, but most of this can be done by staff, actually as part of a revamp of the jury management system that's underway, using machine readable forms, much like the ballots that all of us filled out last month. And it's as simple as that. We had a terrific subcommittee. I want to thank the leadership who gave us such great people, both on this task force and our subcommittee, because we had great resources of personal experience and tremendous support from Chris Pleasanton on the staff. Thanks.
Great. Thank you so much, Dean Fisher, and thank you again for all of your work. This is exciting work for sure. Is there anyone who has any questions or, oh, I see a hand already. Saw it and then it went away. If anyone has a question or comment, please go right ahead and unmute and you can go right ahead.
Yeah,
There's Attorney Weller.
This is Harry Weller. Can you hear me?
Yes. Yes.
My question, Tim, still goes to how early in the process do you expect to get data? Because the master lists don't have that data on ethnicity, and therefore, from where you formulate the summons list, which is your greatest outreach to the community. And I don't see anything here about being able to try to reach at that level, actually the summons process, to find out, to have data on where you can, a starting point from data, so you can measure the loss thereafter.
Right. So what we envision is that the machine readable forms will be the first form that a potential juror receives and hopefully fills out either on the web or in paper, depending on what access they have. The records, the digital records should include all the summons that are previously sent out, but it won't include information that only the juror could supply, for example, race and the like. And so that can be part of the system, but it won't include that element that only the individual can supply about themselves.
So can I just follow up on that?
Mm-hmm.
I get the impression then that this is really more for Batson data than for anything else.
Well, the system, the adjustment that the statute enables is to ask additional questions about identity and personal characteristics. The system that the jury management system that's being developed can easily track differences, for example, in response rates based on zip code and the like. That can be done already. That didn't need the statute to change, and that'll be part of the system inherently anyway.
Thanks, Tim.
Thank you, Attorney Weller. Any other questions? Comments? All right, hearing none. Thank you again. Thank you, Dean Fisher.
You bet.
All right. Next up, we have juror summoning. We have Ms. Harris and Attorney Weller. Is there anyone who would like to present for jury summoning?
Yes, I was volunteered by Esther to speak. First of all, I want to thank my subcommittee, our subcommittee. These people work very hard. They put in a lot of time, a lot of thought. When you mentioned about open debate, we had it, and people were persuaded, to move their points of view as a result, or to reach compromises. And working with Esther has always been a pleasure. And Karen Sandler really was invaluable keeping everything coordinated and keeping our dates in place and keeping us on time. So I just wanted to register that for the record. Most of our substantive proposals came with our legislation. We understood early on in the process that although the system itself does what it's supposed to do, we lose jurors. There's a disparity between who's summoned and who actually shows up. And there are reasons for those disparities. We lose people for undeliverables. We lose people who just don't show up. We lose people for language and for citizenship. The latter two being acceptable constitutionally, but nonetheless burdensome to a certain population. So our legislation really was designed to try to address exactly those problems to the extent you can address social problems or certain other problems within the context of a summoning process. I think it's been very creative what's been done here. I'm not going to add to it other than to say, I guess the only thing that's going to be costly, Justice Rogers, is paying more money for jurors, making sure that they're paid at a wage where people who are lower wage earners can afford to come to jury service, and they can get certain expenses paid that they might not otherwise get paid for in order to serve on a jury. So I think those were our biggest changes that we have initiated with our proposals. We have done, as you can tell from our report, we kind of took this chronologically. We've gone through some different ideas, different things that we checked on. There's areas where we had no recommendations. Where we do have recommendations, however, is on the summonsing envelopes and forms. And these were derived from a study and reading we'd done and research we had done on basically mail. There's a whole industry out there that does successful mailings, and they have best practices. There's debates about best practices, but certainly there are best practices. And we've tried to adopt some of those. But probably the most important changes, along with just the reminder envelopes, is it has to be clear in the jury material early on two things. One is something that we think would be helpful would be a rip-off, a tear-off for an employee to give an employer so they don't have to be the one explaining the fact that they have to serve on a jury and the employer has to pay them. Some people, it just may be too intimidating to do that. And the other things are to make the envelope itself less intimidating, make it more inviting than intimidating, but also within the jury material itself to stress the changes we made on how much that you're going to get paid, to really make that clear, to make it clear that you're going to get family expenses paid, you're going to get travel paid, and here's basically the framework for that. That information up front and stressed maybe in boldface or somewhere in the material we think might be very helpful. The other thing that is important, and I think it came across both in our looking into the mailings and also into looking into the concept of enforcement, that people don't seem to understand that something they get in the mail is an order from the court. That there really there's an obligation that comes with this. It's not just a mailing saying, we invite you to come, it's your order to come. So making sure that that's also clear in the documentation. We think that those are the things beyond our legislative proposals that might help improve participation. I just want to add one thing on enforcement. We don't believe enforcement is something we should do now. There's some wonderful proposals on outreach, educational proposals. They're the changes we've made to the summoning process itself to try to reach people who either don't show up or because of undeliverable mails don't get summonses. We think that those should be stressed and tried at first before we consider enforcement, because enforcement comes with a lot of expense and a lot of baggage, and it should be considered later on. And I think it's well set forth there. What are the pros and cons of enforcement at any time? Thank you.
Thank you so much, Attorney Weller. And we'll just take a moment just to remind everyone, especially those joining by phone, to just remember to mute yourselves, please, so that we can hear without interruption. But I think everyone was able to hear Attorney Weller. Is there anyone who has any questions, any comments for jury summoning? And I don't see anyone raising their hand, so if anyone wishes to speak up, if they have anything to ask or say. All right. Thank you so much. Thank you, Attorney Weller. All right, moving on, we have implicit bias in Batson. That was Judge Gold and Judge Levine. Is there anyone who would like to speak on behalf of that subcommittee?
Yes, Judge Williams, Judge Gold, and I was asked by Judge Levine to speak on behalf of our subcommittee. As I just mentioned, the subcommittee was chaired by Judge Levine and myself. And like the other speakers, I want to thank the members of our subcommittee for their hard work, and also recognize the extraordinary efforts of Paul Doolittle, who was our liaison. Our members were divided up into 3 working groups. Each of the groups has submitted a report to the task force for its consideration. I'll quickly summarize the work of each of those working groups. One of the groups examined the existing Connecticut jury instructions, subject of unconscious bias, considered the effectiveness of those instructions, and compared them to similar instructions that are given in other states. Perhaps most notably, the group determined that Connecticut's instructions are among the best, if indeed not the best, in the country, as the majority of states, in fact, give no instruction at all on this important subject. The group and the subcommittee has made a number of recommendations to improve upon the language of the current model charge and to give the instruction at a point in time that will best serve to emphasize its significance. All of this being done with an eye toward ensuring that jurors will be alerted to the existence of and the risks attendant to the unconscious biases that we all have. Our second working group examined peremptory challenges generally, measured their historical importance as a means of ensuring a fair trial against their history of misuse, and considered the extent to which it would be appropriate to restrict or curtail the use of peremptory challenges in Connecticut, primarily by means of reducing the number of challenges that are statutorily provided to each party in both civil and criminal cases. Ultimately, the group did not recommend any change to the existing statutory scheme regarding the use and number of challenges, and I would refer the task force to the very comprehensive report of that working group, which chronicles the reasons for that conclusion. Our third and final working group was asked to examine the shortcomings of the existing Batson structure and to propose a revised procedure by which a trial court confronting a challenge to the use of a peremptory challenge, or an objection rather to the use of peremptory challenge, could more effectively determine whether a juror's race or ethnicity had played a role in a party's use of a peremptory challenge. The rule that we have proposed was patterned upon, but we feel improved upon, a rule that currently exists in Washington State, and we submit that rule to the task force as a means by which to address the concerns raised by the justices in Holmes about the existing Batson structure, and as a means by which to ensure that jurors of color are not excluded from service on a jury because of their race or ethnicity. The subcommittee members are proud of their work and submit their reports for your consideration. Thank you.
Thank you so much, Judge Gold. And I did have to externally mute the people who called in. So if anyone from that crew wishes to speak, you can unmute yourself. And similarly, if there's anyone who has any questions or comments on the subcommittee, you may be heard. I'm scrolling through and don't see any hands raised. So if there's anyone, oh, I do. Attorney Weller.
Yes, I'm sorry to be the one to voice my view.
Not at all. Please go ahead.
I really have difficulty with the general rule that has been supplied. Several things that I find problematic about it. Most importantly, at least in my level of knowledge, is the appellate review standard. I just think the appellate review standard is inappropriate, and for a couple of reasons. I think this idea that first raised its head in the LaPointe case, I believe, that an appellate court can somehow make review of events in the courtroom that have dynamics that only occur in the courtroom. To me, doubtful. I just don't think that the court is competent to do so. So to try to split the hairs between factual findings that are clearly erroneous and then sometimes de novo review over the standard, I think is inappropriate. The reviewing court can't determine credibility. They can't see what's going on dynamically between the parties. And I understand later in the rule, there's this idea of making a record, which I think has its own practical problems. And maybe I should have prefaced this with the idea is, unlike Washington State, our peremptory challenges and our individual voir dire are constitutionally protected. It's not simply a statute. So we're dealing with something that's got very high value in the state of Connecticut. So I have difficulty with the appellate process generally. I think it should be an abuse of discretion standard. I don't know if someone wants to deal with that first, because I have several things that I'd like to address here.
Judge Williams or Justice Rogers, how do you wish for the subcommittee to proceed? In responding, or I'll take a cue from either or both of you.
Yeah, well, I mean, I'll say that this is certainly an area that is an area of concern that is expressed in many ways in the final proposal of the subcommittee, and various points are expressed in great detail. Beyond that, Judge Gold, would you like to be heard further?
Well, if we're dealing with these concerns that Mr. Weller has one at a time, it's clear from the reports that were filed, along with the statements that dealt specifically with appellate review. This provision of the rule generated quite spirited debate, and the group was pretty much divided right down the middle as to whether or not any rule any provision should be included in the rule on the subject of appellate review, and if there was to be one, what that standard of review should be. Many of Harry's concerns echo those that were expressed in our debate, but by the slimmest of majorities, that rule, which contained an appellate review provision, was adopted by the majority.
Right, and I think, it is all laid out there very clearly, and, we're also fortunate to have the Chief Justice actually with us today, so I'm sure that he's going to take into consideration these concerns and make an ultimate decision as to how the court wants to go.
I take then that this isn't going to be something like with the legislation where we looked at it and we voted on it.
Go ahead.
Yes. I'll say that these final proposals really do lay out in great detail the various positions even within each subcommittee, and I think that they sufficiently allow the Chief Justice and anybody thereafter to work from here, knowing full well what the competing positions are. There's also been some suggestion from members of the task force as a whole that any final recommendation or final report that's submitted to the Chief Justice and the Chief Court Administrator, that they continue to seek further input from, for example, seasoned trial judges, seasoned trial lawyers, before taking further action on any of the, especially the more contested areas of the proposals. And some of these proposals will have further review and discussion necessarily, whether it be proposed modification of of one of the rules of practice, whether it be, for example, with the legislative proposals, they have to go through the legislative process. But the vote that we'll be taking at the end will be a vote as to the final report as a whole, together with all of its, competing positions, to put forth a truly comprehensive set of proposals. So I hope that kind of answers the question.
I appreciate the fact that they did include the dissents. I know we did that with our legislation as well, because everybody expressed their opinions quite clearly. I just didn't know how we were going to proceed. Thank you.
Of course, thank you. And I think Attorney Weller, did you also have follow-up questions?
Not at this point, no.
Okay. Does anyone else have any other questions or comments regarding the proposal of implicit bias in Batson? I'm scrolling through and I don't see any other hands raised. All right, thank you so much. Finally, we have an opportunity to hear from Juror Outreach and Education, which is Judge Alexander, Attorney Merced Agosto. Would anyone like to be heard on behalf of the subcommittee?
Thanks, Judge Williams. With respect to our group, again, like the other co-chairs, I would really like to thank everyone who participated. They were extremely energetic and inventive, and each person contributed to some portion of our final report. And we broke it down basically into the recommendations to revise our jury material and update it so that it becomes more welcoming and less intimidating, and also to really commit to having a permanent community engagement with certain groups that appear willing and able to assist us in getting our outreach out. One of the things we looked at was a variety of states. Arizona had something known as a Juror's Bill of Rights, and while we wouldn't adopt it in its entirety, I think that the concept that was presented through that showed the jurors what their responsibilities were, and also reflected to them how important the court believes their duty is in our community. Second, we really believed it was important to establish a core program which could be used by diverse groups, whether it was bar groups, whether it was school groups, or whether it was community organizations, but a core program that really allowed, again, the judicial branch to go out with real people in real time answering the questions that persons who are summoned to jury duty have. And so we hope by establishing that kind of permanent program with connections to the different bar groups, with connections to different school organizations, that we can, again, expand our outreach so that it is something that's known in the community, and we continue to expand our jury pool. Thank you.
Thank you very much, Judge Alexander. Does anyone have any questions or comments regarding the proposal of Juror Outreach and Education? Judge Alexander, you're getting off easy. I don't see
I'll take it. Thank you.
All right. All right. One last chance to circle back. Does anyone have any questions, any commentary regarding any of the proposals of any of the four subcommittees at this time? All right, while I let it sink in for a moment, I just want to thank you all again, not only for your hard work, but these are, as you can see when you look through the work of each of the subcommittees, these are not generalized ideas. These are, clearly thought out, specific roadmaps to achieve your stated goals, and that's incredibly amazing. As we mentioned, if approved, these proposals as a report will be presented to Chief Justice Robinson and also to Judge Carroll, the Chief Court Administrator, for any further action that might be taken. At this time, I think it makes sense. It sounds like everyone's pretty much ready to vote. Again, this is a vote not as we did with the legislative proposals where we really, broke them down one at a time and in some cases chopped them up a bit for separate votes. This is a vote to have a final report of containing each subcommittee's final proposals, together with the comments in opposition to certain areas. This is a vote, again, on the final report in its entirety, together with the commentary in opposition of certain points. So is there anyone who wishes to move toward a vote to approve the submission of the final report together with its commentary in opposition?
So moved, Tim Fisher.
Thank you, Dean Fisher. Do we have anyone seconding it?
Second, Judge Abrams.
Thank you, Judge Abrams. All right, all in favor?
Aye.
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 All opposed? I'm scrolling through, I don't see any hands raised. Any further discussion? And it looks like the final report is approved unanimously, with, of course, the caveat that people have expressed concerns with certain specific areas within the final proposals. Again, we do have Chief Justice Robinson here, and I will say, just before I get to that, I will mention that obviously some of these proposals do have competing positions raised in there, and they are raised, they're addressed personally. That you have certain subcommittee members who signed on to certain portions just as a matter of form. Just as a matter of form, I have a question on whether people feel that it should be submitted in that way, together with people's individual names attached to certain positions, or whether it should just be presented in a format that shows the competing positions within a subcommittee. Does anyone have any strong feelings one way or the other as a matter of form there?
Well,
I can see arguments for both sides here. On the one hand, judicial opinions do attach names of jurists to their position. On the other hand, it also personalizes the positions perhaps unnecessarily. On the other hand, people might find it important to say why they, in their role, oppose a certain position. But one thing that's clear is that people have raised very specific reasons why they oppose some of the proposals, and so we can hear from you if anyone feels strongly one way or the other whether names should be attached to those positions. I think Justice Katz, yes?
I can only speak for myself. I view the general rule that we worked on to almost be a per curiam, and the other opinions, as you indicate, concurring or dissenting opinions. So at least speaking for myself, I'm fine to have my name attached with the addendum. I also want to take the opportunity to thank Judge Gold and Judge Levine, because they really, marshaling us was not an easy feat, and they did a phenomenal job. And I think accordingly we have a phenomenal product. Thank you.
Thank you so much. Anyone else have any position one way or the other on the form? All right. Again, thank you all for your incredible work. Chief Justice Robinson is here with us. Mr. Chief Justice, I want to thank you again for, on behalf of all of us, for including such a truly diverse group of people to undertake this very serious work and to have this opportunity to be heard. We'll certainly get this final report to you as soon as possible. But if you would like to address the task force in any way, I'll give you the floor.
I would, and thank you very much, Judge Williams. I cannot thank you all enough for doing this hard and very necessary work. I'm actually somewhat emotional at this moment now. You know, when I think about all the things that happened in this last year, I keep hearing this theme in my head about 2020. And that is 2020 wasn't the disruption that we wanted, but it may have been the disruption that we needed, because we are speaking now about things in ways that we never did before, looking at the role of the courts the way we never did before, and actually making some real change. And I appreciate all the work that you've done. I have to give a special shout out to my predecessor, Chief Justice Rogers, for all the work that she did. She laid the groundwork for all of this and showed me how it's not just enough to do a study and write a report. You have to act on those measures, and that's exactly what we are going to do. I also want to thank Judge Levine for his dissenting opinion in Holmes, which was the genesis of a lot of ideas on how we should approach to make the changes that we need to make. For those, I understand that there were some concurring and dissenting opinions and things of that nature in this group, and I'm so glad that there were. And the reason why I'm saying that is because I wanted everybody to come to the table and really express themselves about this really important issue. And if anybody held back, it wasn't going to work. I mean, this body needed credibility, and I saw to it that I could put some of the most incredible minds in the state of Connecticut on this committee, and it did work, and I really appreciate it. So once again, thank you for the work you've done, and I guarantee you that this will not end up as some dusty report on my shelf. We will act on it, and I honestly believe that Connecticut's going to be in the forefront. And once again, we are going to be a model state in another area. I can tell you, I've already started talking to the folks at NCSC and at the Council of Chief Justices about the work we're doing, and the other states are very interested in hearing what we're going to do. So we will be passing this information on. The work that you're doing is not going to just benefit the state of Connecticut, but every state in the union. Thank you very much.
Thank you so much, Chief Justice Robinson. All right, Chief Justice Rogers, would you like to be heard?
I have nothing else to add except, again, to thank all of you. It's been a great opportunity for me to work with some people that I worked with a lot in the past and some new folks as well. And again, it's been a wonderful experience for me as well. So thank you.
Thank you, Chief Justice Rogers, and thank you all of the members of this task force who really poured everything into this work, and you were a part of history. So thank you so much. Any other discussion from anybody? All right, for the final time, motion to adjourn.
So moved.
Thank you. Any second?
Second.
All right, thank you all. The meeting is adjourned.
Happy
Thank you.
holidays.
Everybody, happy
Happy
holidays.
holidays. Stay safe.
Holidays,
and follow
everybody.
storm.
Happy